Attorney Advisor with the Office of Open Government. Thank you for joining me for Ethics Week 2021. I will be presenting the Freedom of Information Act 101, the path that leads to openness and accountability. I will cover step by step the basic process of the Freedom of Information Act. Please feel free to ask questions. I will address the questions in the chat at the end of the presentation. The Office of Open Government is an independent office within the Board of Ethics and Government Accountability within Vega. OOG is charged with advancing open governance in the District of Columbia. Director Allen serves as the city's advisor to FOIA officers and provides formal as well as informal advice to agencies seeking guidance and compliance. The Office of Open Government advocates for fair and efficient FOIA processing. The office also assists members of the public in filing proper FOIA requests. The OOG is responsible for advising and training public bodies on the requirements of the DC FOIA, as well as the Open Meetings Act. The District of Columbia Freedom of Information Act is a DC law that gives the public the right to access information from the District of Columbia government. District of Columbia government must release information that is requested unless that information is protected from disclosure. The public policy of the District of Columbia is that all persons are entitled to full and complete information regarding the affairs of government and the official acts of those who represent them as public officials and employees. DC FOIA applies to Mayor Bowser, agencies, and the Council of the District of Columbia, all public bodies. Applicable FOIA regulations can be found at 1 DCMR, DC Municipal Regulations, Section 400. The regulations contain the rules and procedures to be followed by all agencies, offices, and departments of the District of Columbia, and all persons requesting records pursuant to the Freedom of Information Act. Each government agency has the responsibility to designate an individual as its Freedom of Information Act officer. Each agency must post on its website the name, title, address, as well as telephone number and email address of the designated Freedom of Information Act officer. Any person may request records. Any person has a right to inspect and at his or her discretion to copy any public record of a public body except as expressly provided by exemptions from disclosure. There are records that should be made available without the need for a FOIA request. Examples of some of those records are an employee's salary, employee's title, as well as employment dates, contract expenditures, budgets, manuals, policies, rules and opinions, orders, and final meeting minutes of open proceedings of public bodies. Public records includes all books, papers, maps, photographs, cards, tapes, recordings, vote data, or other documentary materials, regardless of the physical form or characteristics prepared, owned, used, in the possession of, or retained by the public body. Public records also include information stored in an electronic format. Submission of a FOIA request. Requests may be made orally or in writing, but Freedom of Information Act officers may request that the oral request be submitted in writing. And that's very important for the requester and yourself to be on the same page. So it's best to ask that the request be submitted in writing. Requests may be mailed, faxed, email, or submitted through the DC FOIA portal. A request shall reasonably describe the desired records and, where possible, specific information regarding names, places, events, subjects, dates, files, titles, file designation, or other identifying information should be supplied. Time is of the essence whenever you're dealing with the Freedom of Information Act. The response time for a request is usually 15 days, and that excludes Saturdays, Sundays, as well as legal holidays. Requests for body-worn camera footage. The Metropolitan Police Department has 25 days to respond to requests for body camera footage. The FOIA request may be extended, the response time may be extended by 10 days if there are unusual circumstances. And it may be requests consist of a voluminous amount of records. You may need to consult with another agency. And regardless of what time period you're working on, you must notify the requester in writing of these time periods. The requester must know, give a reasonable time and date as to when the request will be completed. FOIA requests. As soon as the FOIA request is received, the clock starts to tick. Time is of the essence, as I said, with every FOIA request. Time is very important. Freedom of Information Act officers should acknowledge requests as soon as possible. We recommend acknowledging requests within 24 to 48 hours of receipt. If your request is received via FOIA Express, please know that there is an automatic acknowledgement for requests that go through FOIA Express, so there's no need to write another acknowledgement letter at that point. Where the information supplied by the requester is not sufficient to permit the identification and location of the record by the agency without an unreasonable amount of effort, the requester shall be contacted and asked to supplement the request with the necessary information. Every reasonable effort shall be made by the agency to assist in the identification as well as location of the requested records. And please contact the requester if supplemental information is needed. When the FOIA officer contacts the requester for additional information, the request is deemed received when the FOIA officer receives the additional information. Requests may be placed on hold until the additional information is received. Once you contact the requester and let them know that you need clarification or if you need additional information, please stop the clock. And that can easily be done if you're using it FOIA Express, but if you're not, you have to make note of it yourself. Once the additional information is received, once the request is clarified, then the 15-day time period begins at that point. All agency employees who maintain records must assist the designated Freedom of Information Act officer as appropriate with the identification and search of responsive records. The agency FOIA officer should, as a matter of business practice, create an affidavit that describes the agency's search for records in anticipation of an appeal or FOIA litigation. In assessing whether a district agency conducted an adequate search in response to a FOIA request, courts look not to the fruits of the search, but to the appropriateness of the methods used to carry out the search. The issue to be resolved is not whether there might exist any other documents possibly responsive to the request, but whether the search for those records, for those documents, was adequate. FOIA exemptions are categories of information that may be exempt from disclosure under the Freedom of Information Act. A government agency that wishes to withhold the information has the burden of showing that a FOIA exemption applies. So you have to have justification to use the exemptions. Exemption 1 covers trade secrets and commercial or financial information. Exemption 2 covers personal privacy matters, as well as body-worn camera footage. Exemption 3 covers investigatory records compiled for law enforcement purposes. Common law discovery privileges, such as attorney work product, deliberative process, attorney-client privilege, falls under Exemption 4. Exemption 5 covers future examination test questions. Exemption 6 covers information specifically exempted from disclosure by statute. National security matters under federal law fall under Exemption 7. Antitrust investigations falls under Exemption 8. Arson investigations fall under Exemption 9. Emergency response plans falls under Exemption 10. Social Security and federal employer ID numbers, Exemption 11. And Exemption 12 covers whistleblowers, unless the name of the employee is already known. Homeland Security records fall under Exemption 13. Exemption 14, sealed criminal records. Exemption 15, critical infrastructure. And Exemption 16, teacher evaluations. If anyone wants to go into greater detail to discuss any of the exemptions, feel free to contact me or anyone in our office, and we'll be able to direct you and hopefully help you with your particular issue. The redaction rule. Redaction allows for the release of records by concealing the exempt portion from public view. Any reasonably severable portion of a public record shall be provided to any person requesting the record after the deletion of those portions which may be withheld from disclosure. The justification for the deletion shall be explained fully in writing, and the extent of the deletion shall be indicated on the portion of the record which is made available or published, unless including that indication would harm or interest protected by the exemption under which the exemption is made. And if technically feasible, the extent of the deletion and the specific exemption shall be indicated at the place in the record where the deletion was made. For example, if you delete one paragraph of a document, the paragraph should be deleted, and exemption 5 or exemption 6, whichever exemption you use, that should be in the place where the paragraph was redacted. Redactions. You must have the correct tool to make the proper redactions. Adobe, as well as FOIA Express, has the proper redaction tools, and those are very helpful. They have the exemptions right there, and all you have to do is click, and it will be in that wherever space you want to have that exemption. When you make those exemptions, please explain why you made that redaction and justify it, and put those reasons in the letter for the requester, because the requester wants to know why you are not disclosing that information to them. Should we answer questions? Answers should not be requested. Questions should not be answered. A FOIA response does not have to provide answers to questions. The agency's obligation in meeting the FOIA request is to provide access to its records, not answer questions. Should we create documents? Do not create records. The Freedom of Information Act does not require an agency to create documents or opinions in response to an individual's request for information or to obtain records from another agency. Will fees be imposed? A public body may establish and collect fees. Fees should not exceed the actual cost of search, review, redactions, and copies of the records. There is a fee structure, types of fees: search, review, or duplication. Agencies may charge commercial requesters for search, review, duplication. Agencies may charge educational, non-commercial, scientific, and news media requesters for duplication. Agencies may charge all others for search and duplication. These are all issues such as fees, such as answering questions. These are all things that have to be addressed in your closeout letter when you're responding to FOIA requests. You have to let the requesters know why you are taking particular steps towards giving them information, disclosing information to them or not. Fee waivers. Documents may be furnished without charge or at a reduced charge where a public body determines that waiver or reduction of the fee is in the public interest because furnishing the information can be considered as primarily benefiting the general public. Requesters should provide a statement in the request that explains how the records will benefit the general public. The requester has to justify why a fee waiver shall be granted. Administrative appeals. Any person denied the right to inspect a public record or a public body may petition the mayor to review the public record to determine whether it may be withheld from public inspection or institute proceedings in the DC Superior Court. A denial of a request for any public record must contain the following: the specific reasons for the denial, including citations to the specific exemptions relied on as authority for the denial, the name of the official or employee responsible for the denial of the request, and notification to the requester of any administrative or judicial right to appeal. Within 5 days, excluding Saturdays, Sundays, and holidays, of receipt of an administrative FOIA appeal, the agency must file a response. An agency may request additional time to file the response to the FOIA appeal by filing a written or email request with a copy to the requester within 5 days, excluding Saturdays, Sundays, or legal holidays of receipt of an administrative appeal. Failure to respond during the 5-day period or an extension granted constitutes a waiver of the agency's right to respond to the appeal. Communication. I'll be ending the presentation with the important issue of communication. Communication with the requester is extremely important from the time of receipt until the time that the request is closed. You must let the requester know that you received the request, and as I stated earlier, we recommend 24 to 48 hours right away. Let the requester know if you need additional information. If you need that additional information, clarification, let them know. Stop the clock. Give yourself more time to, once you receive the information, so you'll have your 15 days to respond to that request once you receive the information. And finally, let the requester know that you need additional time. communicating with the requester and letting them know that the request is being processed and is being processed as quickly as possible. If there are a voluminous amount of records, let the requester know that you'll be able to provide the records on a rolling basis, or build some kind of trust or a relationship with the requester in order to avoid unnecessary complaints as well as unnecessary appeals. Thank you for your attention, and I will take any questions at this time. Our contact information will be here, and if you've been on previous video calls this morning or during the week, you know that the presentation and the slides will be on Vega's website in a few days. Let's see if you have any questions. I do not see any questions from anyone. This contact information here consists of Director Allen's, Chief Counsel Barton, myself, Trial Attorney Orgy, Attorney Advisor Nicholas Ryle, and IT Specialist Karan Bridges. We are all available. If you have any questions or need any assistance, feel free to email me directly or call, and I will be able to assist you as much as possible. Thank you, and good afternoon. Have a good evening, everyone.